Well, good morning and welcome. We are waiting for a few others to join us. We're going to give it about another 60 seconds and then we'll kick off today's webinar. Okay, in the interest of time, we are going to start today's webinar. Good morning and welcome. Thank you all for joining us for today's webinar on the Corporate Transparency Act, heretofore known as the CTA. My name is Jason Castor, and I'm the Chief Business Development Officer for Parsons, Behle, and Latimer, and I'd like to welcome you to today's presentation. Thanks again for taking time out of your schedules to be with us this morning. Before I introduce our speakers, I'd like to cover a few quick logistical items. First, today's webinar is being recorded and you will be provided a link via email to the recording to share with your colleagues and teams that weren't able to join us this morning. You will also in this email receive a copy of today's PowerPoint presentation in PDF format. Second, we have allotted time at the end for Q&A. As you all know, your microphones are muted and your cameras are off. So please use the Q&A function to submit your questions. The format of today's presentation will last approximately 35 minutes, and then we'll have plenty of time to address Q&A at the end, at the conclusion of today's presentation. And finally, it's important to note that today's presentation is a source of information and is not intended and will not serve as a substitute for legal counsel on these issues. You should not act upon the information provided without consulting your legal counsel. All right, with housekeeping items aside, I'd now like to introduce my colleagues and speakers. First of all, Ross Keogh is a shareholder in the firm's Missoula, Montana office. Ross leads the firm's tax practice and focus his practice on helping clients create and manage tax-efficient business structures, capital syndication, particularly in the context of startups, real estate, and opportunity zone incentives. Ross is also the Corporate Transparency Act team lead, where he has played an integral role in helping our clients navigate and comply with the CTA. Also joining us is Tyler MacKay. Tyler is an associate in the firm's Salt Lake City office, where he leads the firm's startup and VC practice, also known as Parsons Lift. Tyler assists clients with initial seed stage and later stage financings, company exits, and securities-related matters. And last but certainly not least is Lexi Deal. Lexi's joining us from our Salt Lake City office, where she serves as the firm's legal operations manager and has also been incredibly instrumental in helping us and our team with respect to coordinating our Corporate Transparency Act efforts in terms of how we're managing that and how we're assisting clients. So with that, I'd now like to turn the time over to Ross Keogh to kick off today's presentation. Ross?
Yeah, thank you very much, Jason, and thanks to everybody for attending today. Today's topic, obviously, is the Corporate Transparency Act. And just as at the highest level, let's see if you want to go to the first slide, we want to really underscore that this is a 2024 obligation of virtually all companies in the United States. Current estimates are around 32.5 million companies will need to actually register and report under the Corporate Transparency Act in 2024. Treasury indicated last week, the first week of registration, there was about 100,000 that filed. That is significantly below pace if that amount of reporting is going to get done. So lots of work to do. And the purpose of today's presentation is to give you a sense of your obligations under the Act to report and how you will go most efficiently and effectively go about that. There are both criminal and substantial civil penalties that can be imposed under the Act for a failure to comply. Many of these penalties will be virtually automatic especially on the civil side, if compliance is not completed in time. This is an act that went into effect 10 days ago. It's been on the books for several years. There's been regulatory guidance being developed. It does impose a substantial compliance burden to many businesses, but registration can be accomplished fairly painlessly through an online interface that is now available and generally accepting applications. We also at Parsons have created a web-based product, which we'll discuss about towards the end of the presentation, designed to help our clients register and comply with the act with ease. So in terms of a roadmap for today's presentation, Tyler's going to kick us off with kind of a deep dive into the act to understand the compliance mechanics. I'm going to talk a little bit more about how we're seeing this act interact with the deal cycle and some of the general mechanics we see with businesses they evolve. And then Lexi is going to provide us an overview of the tool that we've developed at Parsons and how we see how we are planning to facilitate registration for our clients. After that, we're anticipating that we'll have about 20 minutes for questions. And so please, during the presentation, use the Q&A, drop your questions in there, and then Tyler and I will be prepared to handle those toward the end. Thank you for attending.
All right, thanks, Ross. So as mentioned, the CTA has been on the books for a couple of years now. Congress enacted the act on January 1st, 2021, as part of a larger Defense Authorization Act. That act was actually vetoed by President Trump, but then that veto was overridden. So all indications point to the fact that the Corporate Transparency Act and the compliance obligations there are here to stay, at least for the foreseeable future. The final rule governing compliance here was issued on September 29th, 2022 by FinCEN, which is the regulatory agency that oversees Corporate Transparency Act reporting. And reporting officially began on January 1st, like Ross noted. And for entities that were formed prior to January 1, 2024, those entities must be registered prior to January 1st, 2025. So we have the entire year of 2024 to do it, though for reasons that we'll get into in a little bit more detail here, we definitely don't want to sleep on that. So go ahead and go to the next slide, Lexi. The fundamental question when we have an entity and we're faced with Corporate Transparency Act compliance is, are we subject to it? Generally, the answer is going to be yes, but we're going to describe the reasons why. So the first question that we need to ask is the entity in question or organization, is it organized or registered with a state or similar office by filing a document? So most likely, the case is going to be that you have a corporation or a limited liability company, or maybe multiple of these that you filled out a document, signed it, and filed it with a state or tribal office to organize that entity. Similarly, if this is a foreign entity in question here, has that foreign entity registered to do business in a state or a tribal jurisdiction by filing a document? So again, the number of entities here is likely to be in the realm of 35.5 million. The odds are that if you have an entity that you're a member of or a manager of, it's likely going to be a reporting company here. There are several relatively unhelpful exemptions that are less likely to that are frankly unlikely to apply in the vast majority of situations, which we'll get to in a little bit more detail for entities that tend to be subject to higher scrutiny anyway. But again, the vast majority of the time, the answer to this question is going to be yes, and we are going to be considered a reporting company. Lexi, go ahead and go on to the next slide. So what is it that we have to report? We're reporting for the company. We're reporting beneficial ownership information. So that brings the question up of who is a beneficial owner. A beneficial owner means any individual or entity which directly or indirectly either One, exercises substantial control over the reporting company, or two, owns or controls at least 25% of the ownership interests of the reporting company. So the 25% equity interest, that is relatively straightforward. There are some nuances that we could go into there, but for the sake of today's discussion, if you're looking at your capitalization, the capitalization of your entity, and there's at least one person who owns 25% or more, or in the case of the question that was just asked, a single member LLC with one individual or entity holding 100% of the ownership interest there. Anyone who holds over 25% is going to be reported as a beneficial owner. Lexi, go to the next slide. This goes to that question of what constitutes substantial control. So as you can imagine, anyone that is a senior officer, or individuals with authority to appoint senior officers, are going to be individuals with substantial control. So you can think of the CEO, the CFO, CTO, COO, anyone with that C-suite title. In an LLC, it's going to be managers, or if the entity is member managed, likely all of the members, and any other individual who can direct, determine, or have substantial influence over important decisions, such as the nature of the business, major expenditures, disposition of assets, etc. There's also going to be a concept of indirect substantial control. So, for example, in the case of an LLC that may have an entity as a manager, you're going to look through that entity to determine who has control over that entity as manager. Similarly, in trusts, they're going to be likely the trustees, and maybe certain settlors or beneficiaries are going to be considered individuals with substantial control. Anyone who has majority ownership, and including certain financial arrangements. And finally, there's quite a large swath of relationships that could constitute substantial control. As you can see here in this bolded text, any other contract, arrangement, understanding, relationship, or otherwise. So the underlying principle here is, FinCEN is looking for who are the individuals who have the most control of these entities, and we're required to disclose those people. Going on to the next slide here. When it comes to what information we actually do need to report under these filings, we have two categories. One is the company information that we must report, and the other is the information about the beneficial owners. For the company that must report, we have to report the full legal name, any trade names or doing business as names, the current complete street address of the company's principal place of business, the company's state, tribal, or foreign jurisdiction or formation, or the jurisdiction where the company, if it's a foreign company, first registered, and the company's IRS taxpayer identification number. Next slide. For beneficial owners, it's a similar set of information. You're going to have your full legal name, your date of birth, your current complete address, the unique, and then this is where is going to hold up most people, frankly, is the unique identifying number and the issuing jurisdiction from one of either a non-expired U.S. passport, a non-expired identification document issued by a state, local government, or Indian tribe, a non-expired driver's license, or a non-expired passport issued by a foreign government. And then in addition to that, you'll also be required to provide an image of that document from which the identifying number came. So, most likely it's good for U.S. individuals. It's likely going to be your driver's license number, and then a photograph of that driver's license as well, which will be uploaded to the FinCEN's system as part of that process. Next slide, Lexi. As noted before, the penalties for willful noncompliance here are substantial. Civil penalties of not more than $500 per each day that the violations continue up to a total of $10,000 and could include 2 years of imprisonment or both. So again, as the youth say, this isn't something that you want to sleep on. Corporate Transparency Act is, while there is a compliance burden here, and depending on the size of your corporate chart, and the number of beneficial owners and control people that you have, it could be, that burden could be substantial. The consequences for failure to comply can be quite substantial as well. And with that, Lexi, next slide. I believe we're handing that back over to Ross for some of the more boots on the ground application of the Corporate Transparency Act in the context of business.
Well, thank you, Tyler. And so moving to the first slide here. One of the other pieces of the Corporate Transparency Act is a distinction between what is known as the company applicant. And so beginning for new entities that are formed in 2024, those entities, when they make their registration, so any entities formed in the last 11 days, will need to identify the company applicant associated with that entity. That is not a requirement for pre-December 30, January 1, 2024 entities. In addition, if you're forming a new entity in 2024, that entity, at least in 2024, has 90 days to register. So it's conceivable that the first obligation to register will be April 1st, 2024 for an entity that was formed on January 1 or January 2nd of 2024. Now in 2025, that 90-day period is collapsed to 30 days. So just to recap, old entities, vintage entities, pre-December 31st or January 1, 2024 have all of 2024 to register. There's some ambiguity. We're not quite sure yet if an entity that exists in 2023, if you dissolve that entity in 2024, do you still need to register it? Perhaps as part of some entity wind down or cleanup. I think the general consensus now in reading the rule is you're reporting as of the state of the entity when you register it. And so since you have all of 2024, an entity that was dissolved in 2024 wouldn't need to register in 2024 if it was created prior to 2024, if that makes sense. Moving on. So touching base a little bit about kind of why we have this, what I put up on the screen are the articles of organization that we would file for a client that wanted to organize an entity in Wyoming. You know, Wyoming is one of the sort of 3 known states that are prioritized for entity formation, Nevada, Delaware being the others. And you can tell that there's not a lot of information that you provide the Secretary of State, especially in a state like Wyoming. The name, there's sort of an address. It doesn't necessarily need to be a physical address, just a principal office address. You have to identify a registered agent, which can be a third-party commercial service, and then someone who's organized the entity, often me as legal counsel, would sign this document. And that is it. That is the only public record that exists or identifies who owns, controls, or holds the entity. Now, other states, Montana and Utah both, also require that you identify an agent. That is someone who's either the manager or the member of the entity for an LLC that has capacity to act. But that's not the case in Wyoming. And so because of this, there is potential, and we see it, where foreign agents or crime or other sorts of money laundering is conducted through the use of United States entities, because there's very little requirement to identify and disclose the upstream owners. In fact, in many situations, the requirement in Wyoming is less than you might see in jurisdictions like the Cayman Islands, which are known for business entity formation. So that is a lot of the justification that is driving this act and what the act is trying to solve for. We go to the next slide. So one of the other areas that we're going to see a lot of sort of friction is both with respect to trusts and decedents that are beneficial owners of an entity, right? If a trust owns more than 25%. It's important to note that if a trustee has substantial control over the reporting company, they would be a beneficial owner. In addition, each trustee, for each trust that we have, if the trustee is a corporate trustee, they would need identified. And then any individual who has authority or control to dispose over the trust assets would also be identified as a beneficial owner because of that control or authority over the trust. For instance, a beneficiary who has the right to demand the receipt of income or principal would be an owner of the trust for purposes of beneficial owner reporting. Same with a beneficiary that commanded distribution, or a grantor or settler who can modify or change the trust. So if you have a trust that owns more than 25%, it won't be sufficient to just identify the trustee. You will need to then identify the trustee and also individuals or beneficiaries that have control that can direct the outcome of the trust, each as a beneficial owner of the company. Thank you, Lexi. To go back to the company applicant. So this is for 2024 entities forward. Those that are, we have to identify the company applicant in addition to the filing. So the company applicant is the individual who directly files the document that creates the domestic reporting company, or the individual that registers the foreign reporting company, or an individual who is primarily responsible for directing or controlling such filing. So our take of these rules is that if I'm legal counsel and I'm helping my client facilitate an entity, even if I don't submit the filing, if my client submits the filing, if I help them fill it out, I am probably and should be considered a company applicant in that capacity. Likewise, if you use a third-party service to file it, they're probably the company applicant, but the other individual that helps complete those sorts of forms and register the company is also the company applicant. So in many cases, there's going to be multiple company applicants that will have to be disclosed to FinCEN for these new entities going forward. Our approach at Parsons is when we help or aid in the organization of an entity, that we will be providing our clients with an identifier known as a FinCEN ID, if they choose to do their own registration, to appropriately and correctly identify the company applicant. Thank you, Lexi. So what is happening with all this data and where is it going? There's a system that Treasury has developed called the Beneficial Ownership Secure System, known as BOSS, which is going to receive, store, and maintain all of this information. This is a non-public, private database that's primarily intended for use by law enforcement. However, there was a rule that was issued in last December in accordance with the Act that will allow for certain types of financial institutions, such as banks, with certain consents provided by individuals to access the information in the database. So there's the potential that this database may be have other purposes and may actually facilitate business, especially in the context of banking, by allowing financial institutions and others that need to understand who owns entities that they are working with, under, say, your know your customer rules, efficiently and effectively access the information in the database. The next slide, please, Lexi. We spoke a little bit earlier about this idea of a FinCEN identifier. So this is something that is available to any individual, and it is a unique number that is associated with them that they will have and they can give to others to report them as a beneficial owner or a company applicant. Tyler reviewed sort of the information that you have to provide. It's that same passport, a physical address, and also a copy of that ID. And then once you have that FinCEN identifier, you do need to keep it up to date. And so our general recommendation is that if anyone is attached to an entity, more than one entity, you should strongly consider securing a FinCEN ID and having that with you and providing that to others so that they can appropriately report you as a beneficial owner for the company. Here's a list of the exact aspects of the FinCEN identifier. Very, very similar to what we've seen previously. I should note that an individual, as we said previously, that you will want to provide this information and that you will need to, we can go to the next slide, Lexi. If there are any changes to the FinCEN ID, those need to be updated within 30 days. So if you move, if you get a new driver's license, those are probably triggers to update your FinCEN ID, definitely moving. There's not yet any particular guidance on ID that expires, that if you need to update that, but the expectation is you would. with a new image of the ID for once it's expired. One of the benefits is that by maintaining a FinCEN ID, that you won't have to, the company itself won't have to update their report because the FinCEN ID has been updated. That'll automatically log and update it for the downstream entity. So I want to talk a little bit about, we've started this presentation with the thesis that any entity, organizer registered with the Secretary of State needs to comply with the Act. There was a question that chat about sort of kind of quasi-governmental entities that don't have a registration nexus with the Secretary of State. I don't know the particulars of that question, but as a general thesis, unless an entity is registered with the Secretary of State or organized with the Secretary of State or an equivalent tribal entity, they are exempt or not, or to be more precise, are not a reporting company under the Act and therefore don't need to register. It's worth verifying that for the particular entity. But for instance, a general partnership that doesn't register for liability protection isn't required to register under the Act, even though it may be filing a tax return or engaging in commerce or other business. There are a variety of other exemptions. There are two that most people will find helpful. The first is for extremely large, more sophisticated entities. So to the extent, which I'll talk about on the next slide, but there are also some exemptions for wholly controlled entities. Thank you, Lexi. So if you have a company, for instance, a law firm, and that entity has more than 20 full-time employees, has an operating presence in the US, and has federal tax returns with more than 5 million in gross receipts. So this can't be a new entity because it has to have a tax return from the prior year. That entity is exempt from reporting. Now, frankly, most companies that meet these qualifications have staff and people and will be able to report very quickly and very easily. However, the Act exempts them from reporting. It's known as the large reporting company exemption. If we could go back one slide, Lexi. The other two primary exemptions relate to subsidiaries and entities that are considered inactive. Really entities that people forgot existed and failed to register and are probably going to wind down at some point in time. So to the extent you have a single member LLC or a wholly owned subsidiary corporation that is owned by an otherwise exempt company. So if a large reporting company has subsidiaries that do various things that are wholly owned or controlled, those subsidiary entities are exempt from reporting as well. In addition, if you have entities that were in existence prior to 2020 and are not owned by a foreign person, they are not engaged in active business, they have not received funds greater than $1,000, and they do not own any assets, those entities are also deemed exempt from reporting. If we go forward 2 slides, I'll provide the list of the other, I think it has listed the other exemptions. Yes. There are 23 other types of exemptions that we're showing on the right. These relate to generally very sophisticated entities that are already heavily regulated. I will note that nonprofit entities are specifically called out, so tax exempt entities as being exempt. And then otherwise, we're looking at kind of regulated industries, and those businesses that operate and are already registered are exempt from reporting. Thank you, Lexi. So a few observations. This is a 2024 task for virtually every single business owner in the United States. Obviously, for new entities, you're on a fuse. You have 90 days to get your reporting done. Oftentimes, that we are expecting that if we form a company at Parsons, we'll put in place a very basic single member entity agreement, LLC agreement, and we'll just do a registration showing that ownership structure. And then expect to update the registration in 30 days once we maybe finalize who's coming into the entity or owning the entity to be effective and match the dates of those documents that we prepared. This reporting is going to be fairly easy for, sort of flat entity structures where you have a single entity owned by actual humans. If you have multiple tiers of ownership, especially where we see this a lot is in real estate, and reporting is going to be extremely complicated and going to result in upstream beneficial owners that have maybe never been identified or discussed at the lower tier real estate partnerships having to be identified on those beneficial owner filings. This is an area that we are hoping that Treasury will provide some more clarity on as to how to handle this sort of complex reporting. But for those entities, this is going to be extremely challenging, and compliance is going to be very difficult. Again, we're expecting that the FinCEN identifiers for individuals will become a kind of ID that'll be readily provided, whether on cap tables or in correspondence, so that it's possible for downstream entities to quickly and effectively identify their beneficial owners. And we are expecting that these databases are going to be matched with, for instance, the IRS EIN database and also Secretary of State databases to see which entities didn't file. And that those entities that don't file will get a notice letter and will be subject to the penalty provisions, many of them automatic at $500 per day for a failure to file. And that that sort of notice is going to come out probably in 2025 and be really painful and problematic for those entities that didn't take steps to comply. As a result, we are suggesting in clients that think they may even somewhat qualify an exemption to consider going ahead and reporting, and to be over-inclusive and identify and think about beneficial owners for the entity. We've yet to identify any downside to sort of over-inclusive beneficial owner reporting or over-inclusive filing to ensure that you don't either trigger penalties or inadvertently fall outside the intent and the purpose of the act. Thank you, Lexi. I'll turn over to Lexi to give us a preview of how we're approaching this more discreetly at Parsons.
Thank you, Ross. My portion of this presentation is pretty quick, so we'll get to the Q&As here shortly. But I just wanted to take a minute and talk about Parsons' approach to compliance. Parsons has taken a very proactive approach in thinking about CTA, thinking about our clients, thinking about how we want to be a source of truth for our clients. So for the past several months, we have gone on an internal campaign for our Parsons personnel so that we're all kind of on the same page with CTA registration. We know who to contact when it comes to questions about our clients' compliance registration needs, and also how we're going to facilitate the collection of information needed for these compliance filings. It's important to make it clear that CTA registration is not included in our existing legal services that are for any outstanding engagement. This is something that we are specifically engaging our clients on. So if you need or want assistance from our firm for CTA registration, we will specifically engage with you to do FinCEN ID registration, CTA compliance registration. And from there, we will work with you to collect that information through our secure web-based application. We wanted to make sure that this information is not being collected through email and that we have a secure means to collect the information from you and to keep it up to date here moving forward. As Ross and Tyler have gone into, once you file your registration to comply, there are obligations to keep that information current and keep it updated. So the way that we've set up our systems is so that we can, facilitate updating the information and syncing that with the FinCEN BOSS system. Here is a quick preview of the forms that we are using to facilitate some of the collection of this information. Specifically, I'm outlining the beneficial ownership form. This can be used simultaneously to collect a FinCEN identifier number as well. In this particular case, in this particular screenshot, I'm showing there's some conditional logic built in behind the scenes so that in the event that the beneficial owner reporting here has a FinCEN identifier already, it's just a simple enter your name, enter your FinCEN identifier, provide some certification authorization to allow Parsons to file your beneficial ownership information on your behalf and submit, you're done. In the event that you don't already have a FinCEN identifier, you can see here on these screens that there's actually going to be five pages, whereas the previous one, it was just kind of 1, 2, you're finished. And in this case, we would request the information required for a beneficial owner, including your date of birth, address, identifying document, as well as an identifying document image upload. just also wanted to point out that these forms that we've created are mobile compatible, so that, you know, if you're uploading a document from your phone through, you know, logging onto this application through your phone web browser, these identifying documents will open up your camera or open up your camera file, so you can take an image directly from your phone, just to make it as simple as possible. That's the extent of my portion on this slide. I can turn it back over to Ross and Tyler if they want to add any final remarks before we open it up for Q&A.
Well, thank you, Lexi. Thank you, everybody, for attending. I've seen a number of questions come across here, and so Tyler and I will try to answer some of those, but feel free to keep them coming if you have any. And you know, this obviously is a substantial burden for many businesses. However, you know, our experience has been that being preemptive and timely is, unless you have a very complex structure, it's fairly efficient to get through the reporting. And then it's just a matter of being mindful about the requirements to update whenever changes happen with the system. So with that, I want to go to a series of questions about kind of exemptions. And there's a couple in particular relating to one relating to sole proprietors. So unless a sole proprietor has registered with the Secretary of State, again, that is the criteria. The sole proprietor would not need to register themselves through the FinCEN database. This is about organization and registration with the Secretary of State. And there's also been a series of questions around potentially having an exemption or becoming exempt and how to claim the exemption. The database does allow for you to register an entity and then subsequently log back in and claim that you are then exempt. So if you have a company that maybe becomes exempt because it grows into the large exemption, you could go that way. And then if you grow out of it, you do have an obligation within 30 days to update and re-register and file. And so that may be a helpful way for entities to just ensure that they're qualified, is to register their beneficial owners and then register that they have the exemption. And I don't know, Tyler, if you have any more perspective on that you want to offer.
No, I think that definitely covers it. Yeah.
There's a question about sort of entities that are wholly owned by foreign entities that might otherwise be exempt. If the foreign entity itself organized or registered in the United States, then it's not able to register under FinCEN and claim the exemption, which would then allow the subsidiaries to be exempt. So those subsidiaries would need to go ahead and register under the Act. The Act, to our knowledge, does not distinguish, like the KYC does, from beneficial owner and ultimate beneficial owner. We really struggle with the rule that Treasury has issued about having to identify beneficial owners all the way up the corporate chart, instead of just identifying a FinCEN ID for the first tier up and then allowing that entity to have to identify its owners. We think that creates that makes reporting extremely challenging. And that is one area that we are certainly watching and hoping that there's additional guidance and clarity or some rule changes to make efficient more reporting more efficient and effective. We have a question about entities that are registered in multiple states to do business, but are organized in only one particular state. So if you are, the registration is national, and so you are just registering the entity, and it's going to track to its secretary to whatever state it's organized. Fortunately, the registration form requires that you identify every single state that entity is qualified to do business in. However, you do need to identify any trade names or that you've registered with any Secretary of State. So to the extent that you've registered assumed business names in a variety of states, and those are in any way incongruent, those will each need to be identified as part of the registration. Just checking to see, Tyler, have you spotted any other questions that you want to address? We have a question about if there's a LLC that is registered, even if the entity, unless the entity meets the sort of exemption for not having any assets, it will need to register. And so there are any number of entities, and we see these a lot, say for 1031 exchanges, where we form an LLC to facilitate the exchange as a qualified intermediary in a reverse exchange. All of those entities will need to be registered under the Act going forward, even though they may only exist for a small period or moment of time. There's a question about how often you need to file. If there are any changes, those changes need to be made or filed after 2024 within 30 days. So if someone changes as the manager of the company, if you have a change to a beneficial owner, whether as a transaction or somebody else becomes an officer or director, 30 days of that taking place, you have to file the change. Now, for 2024, if it is a pre-2024 entity, you can wait until the dust settles at the end of 2024 and you can file the report just as the entity existed as that date. But once you file the report, our view is that you're under obligation within 30 days to make that update or change. So one potential wrinkle in the rule, right, is say I formed an entity on January 5th, 2024. I would typically have 90 days to register that entity with FinCEN. But if there is an intervening transaction, those beneficial owners, between that 90-day period, then I would need to, arguably, I need to register the entity before that change takes place and then update within 30 days of the change date. So it's required to be very active on the reporting. But unlike many Secretary of State filing reports that we see, there is not an obligation to annually update. So for some entities, say you have a small family holding company that no one ever moves or does anything, once you register, you may be done for decades. It's only if there's a change that the registration needs to be revisited. There's another question on the subsidiaries. If that subsidiary is not wholly owned and controlled by a parent, then it does need to register, even if the parent's exempt. There was a about minors in the context of who may be beneficial owners. There are particular rules around how to appropriately identify the guardian and the custodian of the minor. They're a bit beyond the scope of this presentation. FinCEN has provided some FAQs on their website, which are worth consulting for additional guidance on some of those more nuanced questions. Tyler, do you have any questions that you want to address?
No, I think we've hit some of the key ones here. There is one question. Oh, sorry, Ross, jump in here. There is one question that I saw about asking about how much of the info reported in FinCEN will be available to the public. No information from FinCEN filings will be available to the public at large. These are there are specific regulations and penalties related to the use of personal identity or the information submitted via FinCEN for CTA filings. Certain governmental agencies with specific law enforcement directives will have access. Certain other government agencies may have access, after obtaining warrants. And then there are certain banking institutions that can also gain access to that information for KYC purposes. But those the access is limited and not universal. And then there are significant penalties, both civil and criminal, for misuse of that information. Ross, did I miss anything on the use there? Okay.
Yeah, and just to really highlight, I mean, there are, I think this is an act not to make too many assumptions around. We encounter lots of situations where an entity might conceivably have 20 full-time employees and more than $5 million in gross receipts and really feel like they're exempt from the act. Well, sometimes you drill into that and you realize that there's actually a subsidiary or an affiliate which the employees are employed through, and they're kind of in leased back. We see these arrangements often. And so we would really suggest that if you're going to feel comfortable getting under one of the exemptions and choosing not to register, that you really take a look at the last tax return and confirm that you are in fact filing employee tax reportings that were showing 20 FTE full-time employees, and that you had the gross receipts in the gross receipts box that exceeded the 5 million. Given the penalties and the issues in the act and just generally the low cost of compliance, for most entities, it's probably easier just to go ahead and get the filing put together and make it, instead of having some potential miscue with the desire to claim the exemption. Obviously, there'll be any number of large sophisticated entities that'll qualify without any for that exemption without any blink of an eye, but some may not. Yeah, so there's a great question here about kind of what would happen if we have an LLC that's managed by a corporation that would otherwise be exempt from the act. And our understanding of the rule, and again, this is an area that we really think Treasury should clarify, because this is a problem that's going to present itself often, is that in that case, because it's not a wholly owned subsidiary, that the managers and the beneficial owners of that LLC that is otherwise exempt would need to be reported and identified as beneficial owners of the subsidiary entity. And that in our view makes the reporting really problematic and challenging for large complex structures. And in particular, if you have changes. So if one of those individuals at that, say, parent fund level, who's an officer or director, changes, all the subsidiary companies will potentially need to update their reporting on that 30-day clock for that beneficial owner. And that's part of the reason that we've designed and built the system we have, is to address and be responsive to those sort of cascading update situations that will be caused by changes at the upstream parent level. Well, I just want to thank everybody here, in particular Lexi and Jason and Tyler, for taking the time to present today. Parsons does have a kind of a splash page with some additional resources. If you do have further questions, Vincent does have resources available on their website as well that get into the act. And if you are looking for support in understanding your compliance obligations, feel free to reach out to us, and we can provide counsel, in the context of privilege. And if you're looking for support actually completing your filings, we're happy to get you an engagement letter and talk about those terms if that's of interest to you. So if no final words from Jason, Lexi, or Tyler, again, thanks for attending, and everybody have a great day, and happy 2024.